This is Good Morning San Diego.
Opening statements begin today in what is expected to be a 6-week trial for Donald Trump's hush money case. Criminal defense attorney Vikas Bajaj joins us now to talk more about the historic nature of this case. Vic, thanks for rolling in.
My pleasure, as always.
All right, so you know, Lauren and I were chatting. We kind of know every detail of this case. What will this jury hear in these opening statements that we haven't already heard 1,000 times over?
Now, this is where reasonable minds can differ. In many jury trials, when I, for instance, do not know exactly what each witness will testify to, sometimes it's a good strategic move to reserve your opening statement. Now, many times prosecutors say, boy, that never happens, and it happens in quite a few of my cases, and this is why. If you do not know exactly what each witness, both on the prosecutorial side and the defense side, if you don't know exactly, I mean, to a T, what they're going to testify to in a case that's so technical, to do these gymnastics, to connect dots and find a conviction if you go the prosecution's way, these are very difficult cases to contract with. And an opening statement is a contract. You're saying, ladies and gentlemen of the jury, I'm going to show you this, and you're going to give me a not guilty. When you don't know what each witness may say, strategically perhaps, and they may do it, reserve the opening statement, wait till you hear all the prosecution's evidence, because don't forget, the judge has handicapped and actually handcuffed Donald Trump's defense team in this case by not allowing full disclosure of all the prosecutorial witnesses and their statements.
Another example to some fair-minded people that the thumb is on the scale a little bit here against the former president.
You cannot deny it. Do not believe your lying eyes here, Paul. I mean, that's really what we have to deal with. It is such a stretch to imagine one defendant could be facing a multiplicity of criminal charges of this nature in different jurisdictions on a schedule that's so unforgiving. That in and of itself is a rarity. If you combine that with the ingredient of a former president, that's even more rare, of course, and combine it with weak facts and weak legal theories, it's just unprecedented.
Can we go back to the jury? Everyone has cited the fact, and it's out there, voting data is out there, that this is a heavily blue district, almost 90-10 against the former president. They had sat 500 jury members as possible jurists. What are the odds that there is somebody who's going to be sympathetic to the former president in that selection of 12? Slim and none? Or do you, I mean, you saw what their backgrounds are.
I do, yeah.
As a criminal defense guy, are you saying jury 3, jurors 3, 4, 6 might be our guys or gals?
I like juries. Some people believe that if you can't get out of jury duty, you shouldn't be on a jury. I take the complete opposite look at this. I have complete faith in juries. They end up getting it right. Now, on this jury, we have some people with technical background, and we have lawyers. Now, lawyers understand the high threshold of proof beyond a reasonable doubt and what should be considered and what should not. I believe that is a distinct advantage for the defense in this case.
So you think, I mean, it only takes one, right?
And that's the real difference here. And you will see, and we saw during jury questioning, the Trump defense team allude to a holdout juror. If everyone else agrees and it's 4 o'clock on a Friday and everyone's pushing you, hey, it's guilty, I need to get home, I don't want to be here on Monday, what are you going to do?
Who can stand up to that? It takes a special person, doesn't it?
Well, it takes a lot of people. We have 3 lawyers on this jury, 2 or 3 lawyers. We have adults. We have people with their own voice. I do not believe a jury can be swayed as easily as it could have, let's say, 30 years ago. Individuals have more of a voice now and an opportunity to debate, and I have consistently seen healthy debate within that deliberation room once we hear about it afterwards.
Well, besides the pie-in-the-sky theoretic legal pretzel twisting of this case,
yes,
it's historic in that a former president's in a courtroom when he should be on the campaign trail.
Yes, that's right. But it's historic in the sense that these are relatively minor technical, defensible accusations that are finding the former president in court. It's just eye-opening, and perhaps the jury will get it right.
Vic, we appreciate your time. I suspect you're going to be back a couple more times before this.
Always happy to be here.
We're going to have 6 weeks to talk about it.